Howdy, my name is Brian Foley. I'm a criminal defense lawyer here in Conroe, and I represent folks who've been charged with a crime in Houston, Conroe, and the surrounding areas. Today we're going to have another installation on our series, The Dirty Little Secret in Criminal Law, where I discuss a specific charge, a specific crime, and I tell you the dirty little secret that us lawyers know about that kind of charge that maybe you and the general public don't. So today's charge is going to be assault family member first offense. So what is an assault family member charge? Well, there are things that the prosecutor has to prove in order to convict someone of assault family violence or assault family member. And those are that first, the right defendant, they have to prove who the person they're charging is, caused bodily injury to a specific complainant on or about a certain date within the county of jurisdiction. So if it happened in the Woodlands, it would be Montgomery County. If it happened in River Oaks, it would be in Harris County that they'd have to prove. And so the next question you may be asking is, well, what is bodily injury? Bodily injury is defined by the Penal Code to be any type of a scratch, any type of impairment of physical condition at all, any pain at all. So an example that prosecutors like to give is people have been punched in the stomach. Well, it didn't really leave a mark, but it does hurt, and so that would qualify as bodily injury. So that means if you are charged with assault family member, you could be convicted of assault family member and there be absolutely no visible injuries to the person who is listed as the complainant. And that is something that people find very surprising when they hear about this. It can be very much based on the testimony of even just one witness, maybe just the complainant. There are so many charges that are filed like that, and many that are tried to a jury for the same reason. Another question that I get frequently is about protective orders. Assault family member charges in Texas are part of a group of cases that are authorized to be given what's called a protective order. So let's say you were arrested for assault family member, a girlfriend or a wife has made a report to the police and you've been hauled down to the jail based on her word of what happened. And then what happened next was you probably stayed until the next day or the next time a judge was available, and you were read what was called an emergency protective order or a magistrate's order of emergency protection. In Montgomery County, they call it the first one, the EPO, and in Harris County, they call it a MOEP or a MOEP. It's the same thing. It's authorized under the same part of the laws of the state of Texas. And it allows a judge to impose conditions on somebody for a period of 60 to 90 days. One of those conditions is they can kick you out of your own home. You know, if you live somewhere and, with your wife, with your kids, and you've been charged with this kind of crime, they can actually kick you out of your own home. Now, that doesn't mean that it's going to be forever. An EPO or a MOEP is only going to be good for 60 to 90 days. But what the trial judge can do is set bond conditions which last for the entirety of the case. They can say that you have no contact with your kids, no contact with your wife, that you can't stay in the home, you can't possess a firearm. There's so many different things that can be done, and it's important if you are charged with a crime like this, you need to hire a lawyer as quickly as possible to try to get things back in your side, back in your corner, because attacking one of these bond conditions, asking the judge to change some of the bond conditions or remove the protective order is definitely something that your lawyer can try to do. So how are we going to fight an assault family violence case? Well, the first thing you want to do is try to look at all the evidence. The Code of Criminal Procedure, Article 3914, says that the prosecution has to provide all of the evidence in the case, including evidence that is favorable to the accused citizen. So the first thing I always listen to when we have a assault family member case is the 911 call. That is going to tell us a lot about the case. Does the person on the 911 call sound credible? Is it a third party that doesn't know what's going on, that didn't see the entire incident and is only making a judgment call based on a snapshot of what they perceived? Maybe the person calling 911 is the alleged victim, and they just don't sound very scared. They don't sound credible on the 911 call. That's something that you can look at and attack. What about the photos from the scene? Did the officer even take any photos of the scene? Did it show what had happened just prior to this person making an allegation of assault? Is there a lack of corroborative evidence? Things like neighbors that would have heard the horrible assault that they're claiming happened, but nobody seems to have heard anything until the police got there. Is there a motive to lie for any witnesses? For example, maybe it's a landlord-tenant situation where the person's about to get kicked out of the home or their other home, and they had to stay with someone else. And they have this motive to stay in the home and to kick the other person out. This motive to get that protective order that allows them to stay there and continue to live somewhere. There could be a divorce case pending and someone's trying to get an advantage in a divorce, or maybe the person has immigration issues and they're trying to get a U visa, which is a special type of status in the United States granted to persons who are listed as the victim of domestic violence cases. Another thing you may be asking is, can I be prosecuted if the victim drops the charges? And the short answer there is yes. In the state of Texas, the state is going to be the party on one side of the case, and the accused citizen, or my client, is going to be the other party. The alleged victim is not a party to the transaction, and they don't have a say in whether the case is filed, whether the case is dismissed, or whether the case proceeds to trial. So it is going to be up to the prosecutor on their own. Now, that doesn't mean that a non-prosecution affidavit, which is a legal document we could submit to the prosecutor's office, that doesn't mean that that means nothing to a prosecutor. It's something that they consider with the rest of the evidence. I was a member of the domestic violence unit when I was in Montgomery County, and I know that the prosecutors who are assigned to that division look at these cases very carefully, and they are not going to make a decision to dismiss a case just because someone has given a letter like a non-prosecution affidavit. It's going to take a full legal challenge to your case in order to get a dismissal in Montgomery County. Now, when I was in Harris County, they have a similar program. They call it FCLD, Family Criminal Law Division, and they too are looking at these cases very closely. And in fact, if there's a non-prosecution affidavit signed, or there's been a recanting phone call by the witness, the case doesn't get dismissed. In fact, it gets transferred to prosecutors who are more capable of handling those kind of cases. Your case actually becomes more difficult to get dismissed or to win at trial if it gets transferred to the FCLD division in Harris County. So what is the punishment for an assault family member case? If it's the first offense, then it's going to be a Class A misdemeanor, up to a year in jail and up to a $4,000 fine. And what is the dirty little secret with assault family member cases? Well, the dirty little secret here relates to, what does the word conviction mean? So, the upshot here is that if you plead guilty in any way, if you get a deferred adjudication probation, that means a probation that ends in a dismissal of the case. And let's say you apply for a job and I ask, have you ever been convicted of a crime? And you've completed a deferred adjudication. You can say no, you were never convicted of the crime to that employer. But if a prosecutor finds a case where you have been alleged to have committed a new domestic violence assault or a new assault on a family member, then they could charge you with a third-degree felony, enhancing your new charge to that higher level of punishment for doing the same thing. This is true no matter if you plead guilty and go to jail, if you plead guilty and get what we call a straight probation, where you would have to say you're convicted, or whether you plead and get a deferred adjudication where the case is dismissed. all of those are usable by a prosecutor to enhance your charge. And the judge is supposed to do something specific here in a family violence case. They're supposed to make an affirmative finding of family violence on the record and written into the judgment. If that does not appear on your prior judgment, you are still not out of the woods. The prosecutor could still go back and try to prove up the old case. That is why it is so critical to get a criminal defense lawyer who understands this law and understands exactly the type of situation you could find yourself in, not just today, but years down the road.